you can start.
Okay. Thank you very much again. And again, good afternoon, everyone, and welcome to today's webinar organized by the Family and Succession Law Special Interest Group. This webinar is devoted to awarding the prize for the best doctoral thesis on comparative family law, comparative succession law, comparative or European private international law in the field of family and succession. We had 11 candidates, one from Germany, one from Switzerland, two from Belgium, 6 from Italy, and 1 from Spain. It was quite challenging, I can say, to make our choice, as all the theses were of a quite high standard. However, after taking various factors into account, and in particular, originality and innovation, scholarly rigor and methodology, comparative depth and intercultural awareness, practical or policy contribution, structure, clarity and academic style, source base and citation quality, critical engagement and interdisciplinary awareness, the prize was unanimously awarded to Leontine Bruinen, who is currently assistant professor at Maastricht University, with a special mention going to Antonio Calzado Lamas and Rachele Zamperini. Antonio Calzado Lamas is currently an assistant professor at the University of Salamanca, Spain, and Rachele Zamperini is currently a postdoctoral researcher at the university, no, at the Institute, the Institute of Comparative Law in Lausanne. I would like to congratulate on all the three of you for your excellent works. I would like to thank Gregor Kristrand, who is hosting our meeting today, Francisco Jimenez Munoz, Ilaria Pretelli, and Denise Wiedemann for their commitment and valuable work. I would like to thank also Nia Ivanova, the ELI officer, for her logistical support, and above all, the Austrian Chamber of Notaries for its financial support. I am delighted to hand over to Teresa Rodriguez de las Heras Palel, whom I would like to warmly thank for joining us today. Teresa, the floor is yours.
Thank you, Elena, and good afternoon, everyone. In my capacity of the President of the European Law Institute, I wanted to welcome you to this webinar. I would like just to address you three groups of words. The first one definitely are of gratitude. I would like to thank the chairs, co-chairs of the SIG on Family and Succession for organizing this prize. I would like to thank to the Austrian Chamber of Notaries for supporting this prize. And I would like definitely to thank to the selection committee in order to work on selecting the best work for this prize. The second words are going to be definitely of congratulation. So congratulate on the winner, congratulate to the nominees, and congratulate to the European Law Institute. Because indeed, we are doing exactly what we believe in. We are promoting and defending the rule of law, and we are promoting and defending talent, research, and science in Europe and in the rest of the world. So I'm absolutely not only happy, but very, very proud that in celebrating our 15th anniversary, you probably know that we are celebrating our 15th anniversary this year. We are not old enough to prepare a doctoral thesis, though, but we are delighted to recognize and acknowledge this excellent, talented research that is indeed contributing to the advancement of the law, and they are contributing as well to have a strong foundation in our society that is now unfortunately faced to extremely unstable and very, very tense and difficult moment. So I would like just to welcome you, express my gratitude, my happiness, and congratulations to the SIG, to the Austrian Chamber of Notaries for doing this with us, and to all the participants in this webinar and definitely on the prize. Congratulations and thank you very much.
Thank you, Teresa, for your kind words. And yeah, we are delighted to be able to offer this prize to these candidates. It was a real pleasure to read all the works that has been done. And now I think the floor is back to Gregor, who will read the motivations.
No, Ilaria. The floor is of Stefan Mattik D'Antoni, the representative of the Austrian Chamber of Notaries.
Thank you. Thank you very much.
Please.
I'm delighted to see you, Elena and Gregor, and I also would like to thank the president of ELI for the words and also for mentioning the partnership with the Austrian Chamber of Notaries. We are delighted and honored to be a partner with ELI on such a prize and such award because we, as you, are convinced that compensation for research excellence in this area is very important. And I think it is a very strong signal from ELI to award such prize in the area of family and succession law. Family and succession law should be really also on the top priorities of legal research, also within the ELI, and we are very happy that there is this visibility and a clear signal. I was personally also impressed because I read the documents from you, and I was impressed by the remarkable scientific approaches which were chosen by the researchers, and that they have tackled very relevant issues, complex issues, because European issues are always at a degree of complexity which is above the regular level when you remain within the national framework. So very relevant and exploring new pathways, I think, of research in combining, for instance, I could see this with the prize winner Leontine Bruinen, that this combining of family law issues with challenges of migration. I think this is really a very innovative and relevant approach. And in that sense, I have to say it is impressive. We are happy to be a partner for this. And I hope that in a certain way, we can remain in contact also with all of you, with the prize winners, and of course with ELI. And we are happy to continue this cooperation also in the future. Thank you.
Thank you very much, Stefan, for this introductory greetings. Well, now our webinar can start with an introduction by Denise Wiedemann. Denise, the floor is yours.
Thank you very much. I hope you can all hear me. Yes. Okay, so good afternoon, everyone. Before turning to my introductory remarks, let me first congratulate also the prize winner and those two receiving a special mention for their excellent and inspiring research. Leontine Bruinen, Rachel Zamparini, and Antonio Calzado Llamas. So very well done. Congratulations. And now it's a pleasure to me to introduce the topic of cross-border families and successions. The theses that are presented today engage with highly topical and complex questions in comparative family law, comparative succession law, and private international law in the fields of family and succession. In order to situate these contributions, I would like to briefly place them into a broader intellectual framework. In sociology, developments in Western societies over the last decades have often been described under the general heading of modernization. And modernization is not a single development, but rather a cluster of transformations that shape all our social lives. Among the most frequently mentioned features are individualization, secularization, and rationalization. Individualization, as you all may know, refers to the growing emphasis on human beings as the central unit of social organization. Secularization describes the decreasing influence of religion, and rationalization finally denotes the increasing tendency to organize social life according to systematic reasoning and structured decision-making. All these developments have not only transformed society at large, but also deeply influenced legal systems and thinking. Anne Rötl, the current director of the Hamburg Max Planck Institute for Comparative and International Private Law, has recently explored how modernity has changed both the justifications and functions of substantive family law. Her work highlights that family law today often no longer primarily protects the family as a collective institution. Instead, it increasingly focuses on the rights, autonomy, and protection of individual family members. If we now bring these broader developments of modernity into our world of comparative law and private international law, we can observe similar tendencies. Many of the theses that we had the immense pleasure of evaluating for this prize reflect precisely these broader transformations. Their research question and methodological approaches can often be aligned with the key features of modernity that I've just mentioned. Let me briefly illustrate this. I will first focus on the research questions and then on the methods. As concerning the research questions, all the theses put their emphasis on individuals. Questions based on family as a collective institution appear less central in these works. Instead, the focus shifts to the situation and protection of individual actors within families and successions. First, the prize-winning thesis by Leontine Brünen focuses on individuals who move from one state to another, and her research addresses a particularly complex problem, the recognition of kafala and child marriage across different legal contexts, especially when family law and migration law intersect. And second, Rachel Zamperini addresses the concept of the best interest of the child in family law disputes. The focus on the best interest of the child is itself a clear expression of the individualized perspective that characterizes modern family law. At the same time, it is also notoriously difficult to define and to apply it in practice. And then third, the thesis by Antonio Calzado Llamas examines the patrimonial status of the widowed spouse and surviving partner from a comparative private law perspective and the perspective of European private international law. And modern inheritance law has undergone a significant transformation in this respect. Historically, one may observe that inheritance law often treated the spouse primarily as a trustee of the children's interests. In many modern legal systems, however, the surviving spouse has acquired a much more independent and prominent position today. And again, the emphasis lies clearly on the individual and on the level of protection that legal systems provide. I will now turn to methods, because not only the research questions themselves reflect the broader development associated with modernity, the methods used in these theses also reveal interesting patterns. One, to me, very striking observation is that methods based primarily on legal history or doctrinal tradition play a less prominent role in these research projects with focus on individual interests. And with a less prominent role, I mean less importance compared than they have in earlier generations of legal scholarship. And when it comes to research question on the family law or on the family as an institution. I do not want to say, of course, that legal history or comparative legal history is irrelevant today. However, when research focuses on the interest and protection of individuals, other approaches often come to the fore. In particular, I observe different forms of rationalization in the methodological approaches. And one first form of rationalization can be seen in the strong attention paid to legal practice. Many of the theses, for example, most prominently Leontine Prünen's work, rely on an extensive analysis of case law, including decisions from lower courts. In this sense, comparative law and private international law are approached not only as abstract doctrinal systems, but as a law in action. The goal is to understand, to rationalize how legal rules actually operate in practice and how they affect the individuals involved. And the second form of rationalization appears, as I understand it, in the development and application of doctrinal concepts. For example, Rachel Zamperini takes as a starting point the analytical framework developed by Marietta Auer, particularly the concepts of materialization, flexibilization, and judicial freedom, and Rachel Zamperini uses them to structure her detailed analysis on the best interest of the child. And the third and last general form of rationalization can be seen in the strong comparative dimensions of the thesis. Antonio Calzado Llamas, for instance, undertakes a careful comparative analysis of succession laws in order to evaluate the safeguards that exist against both overprotection and underprotection of surviving spouses. Through this comparative analysis, the thesis contributes to a more systematic understanding of how different legal systems calibrate the level of protection afforded to surviving spouses. Now, taken together, these theses illustrate how contemporary research in comparative family law, succession law, and private international law engage with some of the most pressing questions of modern societies. We saw mobility, pluralism, and the protection of individuals. With this broader perspective in mind on research questions and methods, I'm very pleased to now hand over to Gregor Christantel, who will present the reasoning, I think, for the selection of the selection committee for awarding the prize for the best thesis in 2025. Thank you very much.
Thank you very much, Denise, for this in-depth overview of the thesis, and Gregor, the floor is yours.
Okay, thank you very much, Elena. Thank you very much, Denise. Thank you, everybody. Congratulations, the winner and the mentions. I will now read out the reasoning for the prize winner, Leontine Breunen. The ELI Special Interest Group on Family and Succession Law Selection Committee has awarded the 2025 prize to Leontine Breunen for her doctoral dissertation entitled How Can Private International Law Bridge the Gap Between the Recognition of Unknown Family Relations, such as kafala and child marriage, for family law and migration law purposes? The committee found the thesis to be an original and timely contribution addressing a clear gap in the existing literature. By focusing on kafala and child marriage, both paradigmatic examples of legally unfamiliar or contested family relations, the dissertation tackles pressing questions at the intersection of private international law, family law, and migration law. The work's strengths lie in its clear research question, its careful doctrinal analysis, its comparative design, and its methodological care. The author combines detailed study of national and EU instruments with a carefully designed empirical component based on focus groups conducted with the FAMMove project, producing insights that are at once scholarly and practically minded without overstating its reach. The thesis is further distinguished by an impressive and well-structured body of case law, including detailed engagement with decisions of first instance courts, which reflects a strong commitment to a law in action perspective. Moreover, the dissertation demonstrates considerable comparative depth and intercultural sensitivity. The comparative treatment of Belgium and Germany is particularly effective, and the thesis situates its findings within broader European international frameworks. Importantly, the study offers concrete, usable recommendations that will be of interest to scholars, practitioners, and policymakers concerned with recognition and protection in contexts of cross-border mobility. The committee also appreciated the author's critical engagement with own assumptions, in particular, the idea that private international law was always the starting point in family and migration law. The thesis is well structured and written in precise legal language with helpful summaries at the end of chapters. While some sections might benefit from tighter synthesis of reorganization to enhance accessibility, these points are offered as a constructive suggestion for future refinement and do not detract from the work's substantial achievements. Finally, the committee considers the dissertation to open up important avenues for further research, for example, with regard to the structural limits of private international law in EU migration contexts. The thesis convincingly shows that private international law techniques may lose traction where EU law prescribes an autonomous and uniform interpretation of family-related concepts for the purposes of migration law, thereby preempting classical recognition mechanisms. According to the committee, this would raise broader questions about the relationship between private international law and emerging EU principles of recognition, mutual trust, and effectiveness, which deserve to be further developed in future research. Taken together, originality, rigor, comparative depth, and practical relevance led the committee to conclude that this dissertation makes a significant contribution to the field. For these reasons, the 2025 prize is awarded to Leontine Breunen. On behalf of the jury, again, congratulations.
Thank you very much, Gregor. Leontine, the floor is yours, please. you are.
Thank you very much. I will also first start with sharing my PowerPoint presentation. Yes. Let me first also start with thanking the SIG committee, also Eli, and also the Austrian Chamber of Notaries for this prize. I'm very, very honored that I received it. And I would also like to take the opportunity to thank my promoters, Professor Marta Pertegas and Professor Talia Kruger, for the guidance and support during my PhD journey. I would also like to thank my colleagues who are here online, and I would also like to wish to congratulate Rachele and Antonio. To begin my presentation with, I would like to share with you an example that illustrates the subject of my PhD research. So imagine Amina, she's an 18-year-old Syrian refugee who fled from Syria to Belgium. She got married to Omar in Syria when she was 16 years old. And after being granted refugee status in Belgium, she applies for family reunification so that Omar can join her as a spouse in Belgium. However, this request is denied because the immigration office does not recognize the marriage, as Amina was a minor at the moment that the marriage was concluded. So consequently, Omar is not considered to be her spouse for family law and therefore migration law purposes, and he cannot live with her in Belgium. Later, Amina discovers that she's pregnant with the child of Omar. And when their child is born, Amina goes to the civil register in Belgium to register the birth. And the civil register recognizes their marriage, which also means that Omar is automatically considered to be the legal father of their child. And Amina is surprised that her marriage is recognized for filiation and thus family law purposes, but it's not recognized for family reunification and therefore migration law purposes. And this shows that when a child marriage or even more broader legal institution established abroad, when it is recognized differently for family law and migration law purposes, that in such situation legal uncertainty and also problems can arise. Returning to the example of Amina and Omar, they can wonder which approach is the correct one and on which can they rely. Before I discuss this matter further, I would like to share with you my terminology and also methodology used. So when a person moves from one state to another, the question arises how the receiving state should deal with the legal institutions that concern that person. And this question will particularly arise when the legal institution does not exist or not in that specific form in the receiving state. And in such a situation, you can say that it concerns an unknown legal institutions. And two examples of such unknown legal institutions are kafala and child marriage in Belgium and in Germany. So what is kafala? Kafala is a child protection measure established in countries with legislation influenced by Islamic law. And the term is especially used in North African countries to describe that the care over a child, who is also known the makful, is transferred from the biological parents to another person or persons who are also called the kafils. And what about child marriage? What can be considered a child marriage? Child marriage can be defined as a marriage in which one or both spouses did not reach the age of 18 at the time the marriage was concluded. So if a couple requests the recognition of their marriage, for example, when they are 25, but at the moment of their marriage, they were under the age of 18, I still considered it to be a child marriage in my research. Child marriage is not permitted in Germany. The law legislation changed there in 2017. And in Belgium, it is possible under certain circumstances. So my research examined how private international law is used and could be used to determine the recognition of kafala and child marriage in Belgium and in Germany. Furthermore, I also explored whether private international law could serve as a bridge between the recognition of a kafala or a child marriage for family law purposes and for migration law purposes, with the aim of also achieving more alignment between these two areas of law. And with family law consequences, I meant matters such as determination of filiation, but also name and inheritance. And with migration law consequences, I meant matters such as family reunification and also the legal position of an unaccompanied minor. It was already touched upon, but my central research question was, how can private international law address the disjunction between family law and migration law, specifically with regard to the recognition of kafala and child marriage? So my research consisted of two pillars, traditional legal research and the focus group method. So the focus group method means that professionals are observed and also interviewed. I did that within the context of the FamiMove project, professionals in the field of family law, migration law, and private international law were interviewed and observed. And the FamiMove project was a project co-funded by the European Commission, which involved 7 universities across Europe. And I can also already announce that a follow-up will follow of this project, and that will start this month. As part of the traditional legal research, I examined case law from 2010 until 2021 of Belgium and also German courts. And I presented the analysis of this case law in 8 case studies. You can see on the slide an overview of these case studies. There were 4 case studies on kafala and 4 case studies on child marriage. And 2 were on the family law consequences in Belgium and in Germany, and 2 on the migration law consequences in Belgium and in Germany. And in all these 8 case studies, I investigated how 6 factors influenced the recognition of kafala and a child marriage in Belgium and in Germany. And these 6 factors were the use of private international law, the influence of EU principles such as right to free movement, public policy, the best interest of the child, the right to private and family life, and also legal certainty. Although my research focused on Belgium and on German case law, many EU and also international legal instruments were discussed. So this means that, the research is not only relevant for Belgium and Germany, but it has a broader scope. Unfortunately, I won't have time today to discuss all my conclusions regarding these 6 factors. So today, I would like to focus on my main conclusions and also recommendations. So I begin my research with the hypothesis that if private international law is used in family law and migration law, then more alignment between these 2 areas of law would be achieved. However, at the end of my research, I can no longer fully support this view. And my main conclusion is that while private international law can contribute to bridging the gap between family law and migration law, it's not like a remedy that will let this gap entirely disappear. And I have 2 main reasons for this, which I would like to share with you. So first of all, my research shows that private international law, that recognition based on private international law is in principle necessary to attach family law consequences to a kafala or a child marriage. This is not always the case to attach migration law consequences to a kafala or a child marriage. In some cases, it is not the recognition based on private international law, but it is the factual situation that matters to attach migration law consequences to a kafala or to a child marriage. To make this more concrete, I would like to share an example, and this concerns the kafala. So when family reunification is requested between the kafils and the makful, a relationship of financial dependency needs to exist. And this relation of financial dependency is proved on the basis of factual proof. So for example, whether the kafils wired money to the makful, rather than that the recognition based on private international law is leading to determine whether a relation of financial dependency exists. A second reason why I no longer fully support the view that private international law will let the gap between family law and migration law disappears is that private international law is not the only factor that influences the recognition of a kafala or a child marriage. The case studies show that while private international law remains the main tool for determining how a kafala or a child marriage can be recognized, other legal principles such as the EU right to free movement can override this private international law recognition regime. To illustrate this, I would also again like to share an example. So suppose that a Dutch-Moroccan couple established a kafala in Morocco, and then they live in Spain, and in Spain this kafala is converted into an adoption. Later the couple moves with their child, so with the makful, to Belgium, and then the question arises, what should be recognized in Belgium? Should this be the original kafala, or should this be the conversion of the kafala in Spain? And in my thesis, I submit that on the basis of the EU right to free movement, but also on the basis of the case law of the Court of Justice of the European Union, such as Koman, but also Pancharayevo, I would say that based on the right to free movement, the creation of this new status, so the conversion of the kafala in Spain, should be taken as a starting point in Belgium. Does this mean that there is no role for private international law at all in determining the family law and migration law consequences of a kafala and a child marriage? I would definitely not go that far. When it concerns the recognition of a child marriage as a personal status or a kafala as a legal institution, rather than the proof of a factual situation, I would say that private international law remains a useful leading factor. The case studies revealed that particularly in Belgium, the use of private international law in migration law is not self-evident. And moreover, EU migration law instruments often also do not clarify what the role is of private international law. For example, it's unclear whether terms such as spouse and also child in the context of family reunification, whether they receive only an autonomous interpretation at the EU level, or whether there's also room for the domestic private international law framework of the member states. I would argue or support that the role of private international law is more clearly defined in migration law instruments. I would like to end with emphasizing that the potential of private international law should be exploited more. And in particular, the cooperation mechanisms that are embedded in private international law instruments, such as the cooperation mechanism laid down in the 1996 Hague Child Protection Convention, should be used more, because these mechanisms, they can create more alignment between family law, private international law, and migration law. However, the research has also shown that the legal practitioners working in these domain domains are crucial bridge builders because they can create sustainable networks linking private international law, migration law, and family law. Thank you very much.
Thank you very much, Leontine, for this terrific presentation, and congratulations again on your excellent work and on winning the prize. Congratulations. Now it's time for the special mentions. Gregor will read the reasoning for the special mention awarded to Rachele Zamperini. Gregor, please, the floor is yours.
Thank you. It is also our pleasure to announce the ELI Family and Succession Law 6 Selection Committee has awarded a special mention to Rachele Zamperini, postdoc researcher at the Swiss Institute of Comparative Law, for her doctoral dissertation entitled Defining the Best Interest of the Child in Family Law Disputes from Theoretical Analysis to Practical Application. The selection committee found the thesis to be an innovative contribution to the development of European family law, given its focus on the theoretical basis of the concept of best interest of the child and its mapping of applications. In particular, the thesis draws on classical general theory of law and critical legal studies to develop a model for use in family law disputes concerning the establishment and recognition of legal parentage resulting from adoption, assisted reproductive technology, and surrogacy. Zamperini's thesis is appreciated for its attempt to provide guidelines for the consistent application of the best interests of the child. This attempt is practically relevant, as while the best interest of the child is a recognized cornerstone of European and national family law, its intrinsic flexibility often results in inconsistent judicial decisions. The work combines an investigation into the best interests of the child as a theoretical concept and as a principle of law in action by extensively analyzing and comparing the jurisprudence of the European Court of Human Rights and the national case law. This dual perspective, accompanied by a clear research claim and structure, is the work's main strength, making it particularly original and innovative. The analysis could be extended to additional legal systems, which would further enrich the comparative perspective and strengthen the empirical foundation of the proposed adjudication model. Building on the solid foundations already established, such an expansion would enhance the work's relevance and applicability across a broader European context. Congratulations.
Thank you very much. Gregor, Rachele, it's your turn to present your work, please.
Thank you. I will start by sharing my PowerPoint presentation. Okay, I think it is on right now. So thank you, professors, and of course I would like to first congratulate my colleagues for receiving altogether these awards, and of course to thanks ELI and the Austrian Notariat, not only for awarding our works with these awards, but also by giving us this very precious opportunity to share our work together. And finally, I would also like to thank Professor Valentina Calderai, who supervised my thesis during my PhD. So what I'm going to do with the time I have in my hands today is simply trying to highlight what I think are the core elements of my thesis. What I hope I'll be able to show you what I think it's more interesting and maybe even innovative, if I may. So my thesis started from an observation, from observing the fact that the best interest of the child is nowadays ubiquitous in whichever pieces of legislation, decisions, judgments, etc., involves children and their rights. If on the one hand we can look at this on a positive side of the fact that it is an index of children's rights dissemination, on the other hand, it has also some flaws, especially the fact that it's sometimes it feels more like a formula distilled, like something that is sort of there just formally, and it is a bit empty of specific meaning. And when we look at the best interest applied in context of more strict private law, and in particular in the field I've researched, the one about filiation, family law in the context of filiation, we can see that there are some problematic aspects that distinguish the application, the work of the best interest as legal standard. In particular, it's the great uncertainty it brings to the floor due to its indeterminacy. Also, the risk of abuses, of manipulation almost of the principle, of the standard, and eventually the clear risk of circulation of this more contestable interpretation. Therefore, in a nutshell, what I asked myself was, first of all, can we define once and for all what does the best interest of the child mean? Can we give him a definitive content? And then, is it possible to distinguish the different interpretations and separate those that are legitimate from those that feels like manipulations of the concept? And eventually, if it is possible to interrupt this cycle of circulation, risk of circulation of contestable interpretation. To do so, as it has already been told by the Professor Christantot, I adopted a double approach, and in the first part of my thesis, I focused on on a more theoretical study and theoretical analysis, and I tried to provide a critical assessment of the best interest of the child as a legal concept, therefore framing it both as a principle and as a general clause. By framing it as a principle, I try to identify its essential features that we can find different but always the same in the different levels of the legal system taken into consideration: international law, European law, national. And then this definitely helped in understanding how it works, how it performs, but also I argue that it is not simply a principle, but it is a principle formulated as a general clause. And I choose to deepen the analysis in this direction because I think that when we look at the strict private law area, a principle that comes from international law or even from constitutional law can sometimes feel a bit alien to the scholar who is studying it, or even to those who apply it. But on the other hand, when we look at it from the perspective of the general clause, we have the possibility to look at it from the perspective of a category that is native to private law. And we can benefit from the studies about general clauses and how they can somehow provide a very specific, a very special legislative technique. But what I think is very important of combining the view of principle and general clause is that it allows us to see it as a standard that moves in two dimensions, a more substantive one and a more procedural one. That said, I went forward by sort of rationalizing the concept in the sense of framing its essential elements, subjective meanings, weight, in the framework of children's fundamental rights, in particular with reference, of course, to the UNCRC. The main result of this first part, the output, is what I can describe as a real operationalization of the concept into a model. I try to. I really wish that to be able to link the strong theoretical architecture that I try to build with something practical. And in this case, I think it is this model that I proposed that can work both as a guideline to to follow during the application of the principle of the standard, the best interest, as well as a standard to evaluate how it was applied. That said, so what I did in my work was apply this standard as a benchmark to a large group of decisions. But here, before going on, I would like to say that I think that I can first answer to the first question. That was, is it possible to find a universal definition of the best interest of the child? The answer is no. It is not possible. Because I think that we are looking there at some certainty in the substantive part of the principle. But because we can't find it there, because it is a principle that needs to be applied on a case-by-case basis, then we should look at something more certain in the other dimension, the one of the procedure of how it is applied. Therefore, I think that what is universal there, or what could be universal, should be the procedure, how it is actually applied to single cases. That said, I did use the model to study a large group of decisions from different courts, Italian high courts and European Court of the European Court of Justice and the European Courts of Human Rights, to basically search in each of these decisions the elements of the proposed model. And the results are that on the one hand, it is interesting to see that we can see the different strengths and weaknesses of each court. We can witness how each court influence each other sometimes. And also, of course, we can actually see if which kind of elements have the court's based is determination of the child interests, the child's views, the relevant rights, the individual circumstances, and also how the court, if and how the court has balanced these child rights with the other rights or the other interests involved in the specific case, as well as how, in general, this decision, final decision was reached. This is but just the first set of findings, because to answer my second question, so if it is possible to distinguish the, let's say, reasonable uses from the unreasonable one, it was necessary to pair the first set of results with the further research, the applying the Fallgruppen technique, and therefore start again, look at the various cases and, let's say, put them in clusters based on their operative facts, or in Italian fattispecie, or in German Tatbestand. So based on their operative facts, then we can look for each court how that court has applied the best interest standard to the first case in which it has encountered that fattispecie. And there we can see that the court actually, using it as a general clause, creates a judicial rule to solve that case in interpreting, of course, the best interest. For example, we take the cases, here is just the example about European Court of Human Rights. We take the court, the decisions about kafala, for example, to keep a fil rouge with my colleague's presentation of before. There, the court applied the principle to the first case, the Harodi versus France, and decided that the best interest of the child, in that case, that didn't require the conversion of the kafala into adoption for a great number of reasons, and that this solution was in line with the rights under Article 20 and 21 of the UNCRC. Well, this first rule, looked through the lenses of the model, appears to be reasonable. Reasonable interpretation in the sense that it is in line with the principal objective, which is, as I framed it, the promotion of children's fundamental rights as human rights and the promotion of children's rights as rights holders who exercise those rights in line with their evolving capacity, of course. That said, though, the analysis must continue to create a proper map of the uses, because we have to see when a certain court then takes that rule and applies it to similar cases. Because the particularity of what is special of the best interest is that it always requires an application on a case-by-case basis. And the generalization of a rule that starts from the best interest, its crystallization is against the nature, the casuistic nature of the best interest. And so we can see, for example, that in a further case, the one against Belgium that you can see on the right, the court did actually provided an unreasonable interpretation of the best interest, because it simply took the rule that was created in the first case and applied it to the next case without a proper assessment of the individual circumstances of that case. So in this sense, that's how I proposed to work to create a map and distinguish the uses. And finally, here I'm going to conclude, by studying all these courts and having like a more broad overview of the different approaches and the different ways in which they applied it, and also how each court took advantage of the work of the other courts, we can see really that the best interest is a standard that is always evolving. It's ever changing, and its circulation is not only due to the common legal sources that all these courts on these layers of the legal order have, for example, the UNCRC or also the European Charter of the Fundamental Rights, but also it is clear, especially in more recent judgments, the unparalleled influence that the European Court of Human Rights and its jurisprudence on Article 8 of the European Court of Human Rights has on other courts. Therefore, in this constant circulation, I think by having this bigger picture in mind, it is even more important to be aware of the need of a use and of an interpretation of the best interest that is reasonable in the sense of its consistency and coherence with the whole system of children's rights and children's fundamental rights. That's why I think that, again, the model can be a good solution, let's say, or a good safeguard towards the circulation of misinterpretations, so to speak, of the principle, because it invites to ground each decision on a specific case, and it invites to abandon the language of interest, which is a dangerous language, because we should adopt always the language of rights, because only if we are talking about children's rights and not children's interests, then we are definitely giving the same importance to the rights of the children and the rights of adults, for example. And eventually, of course, the key is providing a transparent justification for each decision, because, as I said, I think that the best interest strongly requires a case-by-case application, but this doesn't mean that it has to be completely detached from the rest of the system. And with this, I thank everybody for the attention.
Thank you very much, Rachele, for this brilliant presentation, and congratulations again on receiving a special mention for your dissertation. Finally, Gregor will read the reasoning of Antonio's special mention.
Francisco.
Gregor.
I think it's my my turn. Yes, thank you.
Yes, well, Francisco. Sorry, many apologies. I have not the latest the latest program. That's why. Yes. So, many apologies, Francisco.
Now. Good afternoon. Thank you to everybody for attending this webinar. And now, well, as Elena has said, I'm going to read the reasoning for the special mention to Antonio Jesús Calzado Llamas. The LI Family and Selection Law, SIG Selection Committee has decided to award a special mention to Antonio Jesús Calzado Llamas for the doctoral thesis entitled Los derechos del cónyuge viudo y de la pareja supérsite en derecho civil comparado e internacional privado. That is, the rights of the surviving spouse or partner in comparative civil law and private international law, which was written at the University of Seville, although he is at this moment an associate professor at the University of Salamanca. The committee considers the thesis a rigorous and substantial contribution to European family and social law. It is distinguished by a methodologically precise analysis of legislation, case law, and doctrine, combined with unusually broad comparative perspective covering 5 major European legal systems: Germany, Spain, France, Italy, and the United Kingdom. And their interaction with EU private international law under regulations 650 2012, 2016 1103, and 2016 1104. This approach allows the author to identify recurring structural tensions between national solutions and the European framework. A particular strength of this thesis is its comparative synthesis and is the lege ferenda reflections on the protection of surviving spouses and partners, and on the persistent miscoordination between lex matrimony and lex successionis. At the same time, the committee notes that some of the proposed remedies, such as expanding party autonomy or introducing additional connecting factors, do not fully resolve these tensions and may conflict with core principles of Regulations 650 2012, notably legal certainty and the unity of the succession statute. These critical points, however, underscore the thesis' ability to expose the limits of current and proposed solutions, and to stimulate further debate on the structural trade-offs inherent in a European succession and matrimonial property law. So, well, I'd like to finish. Congratulations to all the awarder, especially the prize winner and the special mention awarded. Thank you for participating in our prize, and well, congratulations. Thank you.
Thank you very much, Francisco, for reading the reasoning, and many apologies again for taking into account the previous version of our flyer. Antonio, please, the turn is yours, and you are invited to present your dissertation.
Thank you so much. Good afternoon from Salamanca. First of all, I would like to thank the selecting committee for having awarded my PhD thesis with one of the special mention. And my gratitude is extended also to the Austrian Chamber of Notary, to the ELI, and to my co-awarded colleagues, to whom I give my most sincere congratulations. I feel also very honored to share some of my conclusions with such a distinguished audience. Well, here I go. In my thesis, I analyze, in legal terms, how to guarantee the patrimonial protection of the widowed spouse and surviving partner following a triple approach. The first one is the private law approach. And in this part, the topic is interesting as the rights of the surviving spouse or partner depends essentially on several factors. Firstly, the validity and permanence of the marriage or de facto partnership until the death of one of its members. Moreover, the patrimonial status is formed by a balance of rights granted through the dissolution of matrimonial property regime or the effects of de facto partnerships and the succession of the predeceased spouse or partner. Finally, we have taken into account the role of party autonomy in altering the legal balance of the widow's patrimonial status through the study of some of the available state planning mechanisms in several states. From a comparative law approach, we can see that the above-mentioned institutions do vary among nearby states, as it occurs in Europe. To reflect that, we have analyzed 5 countries: Spain, France, Italy, Germany, and the United Kingdom. Why choosing these countries and not others? Well, for 3 reasons. These are the European countries where family relationships with foreign elements are most common. Furthermore, they concentrate most of the legal trends and tradition around the world on family and succession law. And finally, the list of selected countries permits to incorporate the reality of multi-legislative systems, as is the case in the United Kingdom and here in Spain. Briefly, the most relevant differences concerns the very concept of marriage, especially when it comes to the recognition of same-sex marriages, because in Italy it is not permitted, but there's an alternative form of union, which is called unioni di fatto, that can be arranged among people of the same sex. We have also differences concerning the effect of marital breakdown on inheritance rights, especially on a procedural way of thinking, whether it is necessary a final ruling or a mere filing of a petition of divorce, separation, of annulment of marriage to provoke distinction of succession rights. The balance that I said on private law that composes the patrimonial status is also of different configuration among the countries, because some countries focus on matrimonial rights, like for example Spain or France, while others, like the United Kingdom, focuses especially on succession. And finally, there are these several differences regarding the recognition of patrimonial and succession effects of de facto partnership, because in some countries the successory effects are the same as widow spouses, while in others, than most of the regions of Spain, it is not the same. And in that cases, the use of mechanisms for state planning could make the difference between receiving rights after the death of one of the members of the marriage or de facto partnership, or not receiving anything due to the lack of statutory processual rights. Finally, from the point of view of private international law, we focus on 2 main concerns. One is of conflictual nature and consists of the fragmentation of the conflicts of law on the patrimonial status of surviving spouse or partners among several European Union regulations. On the research, we focus especially on the relationship between the succession regulation and the so-called twin regulations of 2016, which regulates the conflicts of jurisdiction and law on matrimonial property regimes and patrimonial effects of de facto partnerships. The second concern is of a substantive nature, as that fragmentation could provoke that the lex successionis and the lex matrimony could be leading to different states, provoking the need of coordination between several laws at the same time. One of the most outstanding conclusions on private international law is the lack of harmonization and recognition of marriage or partnership in terms of civil status as a preliminary question to the granting of family and succession rights. Although the International Commission on Civil Status has developed some instruments to that effect, they have not been widely adopted. Nevertheless, It is worth noting that in the context of European Union, the case law of the Court of Justice is promoting a doctrine favorable to the free movement of civil status situation within the Union in defense of the principle of free movement and establishment of European citizens as enshrined in Article 21, Paragraph 1 of the Treaty on the Functioning of the European Union. Instead, for decisions on divorce, separation, or annulment of marriage, we count on Brussels IIb regulation. However, its application is limited to member state decisions, except in Denmark, and it is not applicable to the dissolution of de facto partnerships. Apart from the scarce objective harmonization, there's also a lack of coordination on the rights that composes the survivor's patrimony, given the mutual exclusion of matrimonial property matters in the succession regulation and that of succession disputes in the twin regulations. However, this exclusion is not absolute, because when it comes to solving conflicts of jurisdiction, Article 4 of both twin regulations allows the competent courts on succession matters to deal with disputes on matrimonial property regime or patrimonial effects of de facto partnership linked to the inheritance. Unfortunately, in conflict of laws, there's not any sort of similar coordination, and we find it unfortunate given that it has been a classic problem among academics and legal practices regarding conflicts of laws. The consequences of that miscoordination can be perceived along the whole structure of the choice of law rule. Departing from the factual assumption, there could be problem of characterization with some institution whose nature, between familiar or successory, is not clear. That happened, for example, in the famous case Mankopf, with the increase of the intestate portion of the widow's spouse as a means to dissolve the German participation regime, the so-called, I hope to say it well, Zugewinngemeinschaft. It is also frequent to mention the French Communauté Universelle avec clause d'attribution intégrale and the usufructo de viudedad in the regional law of Aragon here in Spain. To solve that problem, the factual assumptions should be broad enough to include these rights regardless of their legal nature. Indeed, that solution was provided in Article 9.1 of the Spanish Civil Code, which established that the rights attributed by operation of law to the surviving spouse would be governed by the applicable law to the effects of marriage. Regarding connecting factor, we can see that there are similarities among the three regulations from a geographical point of view, as they refer to criteria as nationality, habitual residence, or close ties with a member state or a state in general. But there are also differences in a subjective level, as the succession regulation concretes the geographical points of connection in the deceased person, while the twin regulation does the same, but with both the members of the marriage or de facto partnership. And the differences are also temporal, because the territorial criteria are also fixed at the time of death in the succession regulation and at the celebration of marriage or partnership in the twin regulations. These problems could be solved through the exercise of partial autonomy if the spouses or members of the partnership share some of the geographical points of connection. But if it is not possible to make it coincide, it could also be envisaged the lege ferenda, an option for the applicable law to the matrimonial property regime in the succession regulation, as it was provided for in the Finnish private international law and as it was considered in the Green Paper on Wills and Succession. Finally, from the point of view of the legal consequence, the legal coordination, the lack of that legal coordination, can provoke that the lex successionis and the lex matrimony would be different, applying different laws from different states and with different philosophy of protection at the same time. That could lead to problems of unprotection of the surviving spouse or partner, or overprotection of that person according to the combination of laws. As a possible solution, direct adaptation mechanisms could be used from the point of view of material law. We can focus, for example, on Article 1931 of the German Civil Code, which allows certain variations on the intestate portion of the widower according to the matrimonial regime adopted, or also the family provision of English law, which is granted on the basis of the analysis of the specific circumstances of the survivors. To conclude, in summary, the issue of the rights of the widow, spouse, and surviving partner continues to be of relevance to legal doctrine and practice, and the entry into force of that regulations has brought to the fore the classic problems relating to the institution. The searching for remedies cannot be done from the sole perspective of private international law, but it must bring together multiple disciplines to evaluate the best solution, either conflictual or substantive. With this, I conclude, giving my thanks again and open to question if you are willing to provide me with some. Thank you so much.
Many, many thanks, Antonio, for presenting an outline of your dissertation, and congratulations again on receiving a special mention. We have now some time left, perhaps 12 minutes, 13 minutes, for a short Q&A session led by Ilaria Pretelli, whom I hand over to.
Thank you, Elena. And of course, I would like to welcome all the public, all the participants to either directly take the floor or insert a question in the chat directed to all of the participants. And as far as if I can take some time to make a brief comment and maybe some questions to the candidates, I would like to say that I was really interested by seeing how there is a need today for a theoretical advancement in the various areas. We have seen, Leontina has set it up very clearly, how the technicalities of can lead to a sectorialization of disciplines that we no longer see as different branches of law, but really separate fields. The way they are presented is really separate fields, which is very dangerous for me, because private international law, for instance, which is one of the most guilty of this technicalization, it's a field of law that has become too sophisticated to be understood by the general lawyer, especially with the very welcome advancement of the European Union. But sometimes I think we are in a phase where we need to be in agreement, at least on the terms that we use. One of the terms used was that of recognition via, but this is a contested theory, and there are also several techniques of recognition. And the main confusion comes from the fact that when we talk about recognition, especially in matters of family law, we're never sure if we are talking about the recognition of a status, the recognition of a decision, an act, the recognition of a situation of fact, and all these are different techniques to which, I mean, what we're looking at is really, how do I give legal effects to an institution which is given legal effect in the country that produced that institution? How do I select these? And of course, the difference in purpose can influence the result. So the first comment that I would have for all of you would be how do you see how do you see this? Do you see recognition as a method, as techniques, as and how can we really separate free circulation from private international law? I mean, free circulation is one of the principles that nourishes private international law, but I don't see them as completely separate methods. I don't know if one of you wants to step in this conversation, or if you have other topics, you are really, all of you are welcome to put them forward. Leontina, I see you.
Thank you so much, Professor Pretelli. I really agree also with the fact that you said that private international law is not always well understood. That was also something that I saw in my PhD research, and especially also in the focus groups that practitioners say this is such a technical area. Yeah, that it's really misunderstood. So that was actually also one of my recommendations and conclusions. Did not share it in my presentation, but I think that there is still room for improvement in showing what the potential of private international law is, and yeah, what it can mean. I think for my thesis, you see that. Private international law, yeah, as a neutral instrument, is in a certain way still upheld when it comes to like the family law consequences. But for me, the combination of private international and immigration law showed that it's that what the idea of what private international law is, that it becomes perhaps the right way to say it, more challenged, that it is not as neutral as it was anymore. And yeah, so I think it is changing in the sense as a I would say as a recognition technique, that it is not as what it was, but it's also used, private international law, by other areas of law, if I can make the distinction between separate fields, and influenced by that. Yeah, I hope that that answered a little bit your question and comment.
Yes, this is a very interesting conversation. It is worth a webinar for itself, of course. But yeah, thank you for addressing this. And as regards I was also very interested by the this idea that Rachele Zamperini put forward about consistency that should be sought through procedure, since it cannot be found in the substantive level. So at least the idea, if I can put it in a divulgative, trivial way, is since we have to observe, since we have to adapt on a case by case, that we have to use like in the best interest of the child. Maybe it is in a way, in the same way where legal precedent is used in common law countries. The casuistic is so detailed that consistency can only be found if we are sure that several layers are examined. So the judge has to see a series of cases and a series of aspects and justify each of them, if I understood correctly.
Yes, indeed. Thank you for this specification of this passage. Indeed, it's in this way, by almost working on a checklist, that it is not completely unknown also to the application of best interest of the child in other areas of law. We see it in migration law, for example, especially there are guidelines from the UNHCR that for ages now have been applied in this sense. And I think that it is interesting to look at also the best interest is applied in other fields. And if I may comment on the topic of recognition that I, let's say, incidentally met in my studies due to the fact that I studied together cases with both only national dimensions but also cross-border dimensions, I have the feeling that there is not a high sophistication in the reasoning of, for example, in the Italian high courts when it comes to, for example, differentiating the recognition of decisions, judicial decisions, and the recognition of or acceptance of certificates. And I have to say, though, that I have the feeling, at least, because I think I've still studied enough this topic to proper structure an argument. But from my first view, I have the feeling that the European Court of Human Rights has some kind of guilt in this, as it does itself does not sometimes in his arguments, in this reasoning, in this talking in terms of fundamental rights, sometimes it really lacks the strict also approach of also distinguishing these aspects that are not of scarce importance. And yes, so that's it.
So the issue I can see here that I would be a little bit wary about is that we are, I think one of the dangers of legal development today is its transformation, its bureaucratization in a way. So we are seeing a degradation, I think, of that's the part of the thesis I really liked, is the one of general principles and the general clause, because of this, because it's an antidote to this bureaucratization. But I can see that even in the case of a proceduralization, the look for a consistency, it could also lead, there is also this dangers of having a checklist. Okay, was the child heard? Because the hearing of the child is sometimes something that has been, we have seen it in the decisions that consider that giving the opportunity, even though it's not genuine opportunity, because it just come here with the child and answer the questions. If you refuse to come here, then we gave you an opportunity. But of course, the person, this was a child abduction case where the person would not go back to the country from where she had fled with the child to give a testimony. And in that case, it was judged that the child had been given an opportunity to be heard. So there is this also, do you see a danger of having a checklist or? Sorry, sorry for that. This is not a very easy question to answer.
I would say that, of course, there is dangers in hyper simplification on the one end, of course, of the approach, because overall, especially, I think when one integrates it from the perspective of the children's rights literature, an aspect that is always important, that probably some more empirical or even studies from different fields like sociology, for example, aspect that is sometimes overlooked is actually the preparation of the people that work in fields when children are involved, the specific preparation of judges, the specific preparation of lawyers, etc., that should give to that checklist the less superficiality and more content. But this is,
yeah, it's a matter of cultural awareness, I would say. So I would like now to ask if I can give the floor to one of you for other questions, if from the public.
I just would add to what Rachele just said that, yeah, I mean, you raised an important point, Ilaria. At the same time, I don't think this is a question of excessive proceduralization, as I see it. It's about technique, conscious adoption of technical rules. And this is not necessarily in conflict with legal, sound legal thinking, in my view.
Of course. Of course. Thank you, Valentina. And I see Francisco with yeah.
Yes, thank you. We are almost out of time, so I would like to make a very short question to Antonio Jesus Calzado. You have studied the German, Spanish, French, Italian, and British systems about the surviving spouses or partners. Where do you think these surviving persons are more protected? Where do you think the protection is higher for these surviving persons?
Thank you, Professor, for the question. And to evaluate in terms, in quantitative terms or qualitative terms, if a country protects more or less surviving spouse, it's difficult because there are many factors to evaluate. I think that in terms of strictly of succession, from the set of countries that I've analyzed, in England, inside the United Kingdom, could be an example of a country where the successory rights for surviving spouse are at the highest level. In terms of matrimonial property law, usually the laws like the common law of Spain, for if we can say that, or France, are more dedicated to the matrimonial property regime, and we could say that the balance is more founded on that matrimonial property regime. A country that I found modelical from both aspects, I think that could be Italy, because the protection of the successory protection through the right to use and the right of habitation of the family home and the right at the death coming from the matrimonial property regime are more or less in a high way. So I think that in terms of proportion, Italy could be a great example. In terms of succession, I think that the United Kingdom and especially English law. And in terms of matrimonial property regime, France and Spain. Not all the regions of Spain, but the regions that follows the Spanish civil code. I don't know if I'd answered properly the question. Thank you.
Yes, it's a bit complicated to simplify the answer. Thank you.
Thank you. So I think the time is up. Thank you for your participation. It was really a very interesting and rich webinar. We are very happy to have had you here, and thank you to all of you.
Thank you so much.
Thank you.
Thank you, and congratulations, everybody.
Thank you.